Ashwin? Yeah.
Yeah, thanks, Ashwin and Vishnu. The screen is visible for me. I hope it is for everyone else on the call as well.
Yes, madam.
Okay, thank you. So we'll start. I don't want to waste any more time. So yeah, so the whole idea of, so I was just listening to the conversation between Shafiq sir and Ansar sir now. So I understand that there's a lot of activities happening in TKM Engineering College, and the idea is to sensitize the students about intellectual property rights, so that we generate, obviously, because a lot of research is happening in universities and educational institutions. So I assume the whole idea of having the session is to sensitize the students about intellectual property rights, with the idea of bringing in more and more inventions and IP being generated out of the organization. So with that in mind, I would like to start the presentation where my task will be to give you an overview of the different aspects of intellectual property rights, so that by the end of the session, I hope you will have a very clear idea about what each intellectual property right is, and you also should be able to distinguish between them, understand, and kind of identify as to what is the IP that you have generated, or what is the kind of protection that is available for your intellectual property right. I'm sure all of you must have listened to a lot of these sessions. But the whole idea is to understand and be able to realize and recognize what is the IP that you have generated, so that you can go for a protection for the same, and what is the advantage that you get out of this protection. We can move on to the next slide, please. So this is just a quick introduction about my firm. I represent Putran and Associates. I am a partner there. Our mission itself is to inspire, enable, and protect innovation. Next slide, please. So we were established in 2004. We have 4 offices. Chennai is where the head office is, where we started the operations. We have offices in Bangalore, Trivandrum, and Cochin. I currently sit in the Bangalore office of the firm, and I'm in charge of both the Kerala and the Bangalore operations of the firm. And we believe in absolutely and total ethical legal practice. I'm a lawyer by profession. I specialize in intellectual property rights. We have a very strong client base, which we have built from our practice since 2004. The whole idea of, and we take a lot of these sessions, interactive sessions and seminars and all of that, with the idea of enabling organizations, not just organizations, educational institutions, universities, into enabling them to innovate and also file patents or trademarks or whatever protection is available for those intellectual property rights. We have local presence in almost all of the states in South India. We also have a strong network of law firms across the world, which help us protect intellectual property rights, register patents, trademarks, copyrights, and all intellectual property rights across the globe. Yeah, let's move on to the next slide, please. So that was just a quick intro about our firm. Now coming to what exactly is intellectual property right. I'm sure this is something that you've heard over and over again multiple times. Intellectual property right, just like how you talk about real property or real estate or a piece of land, intellectual property is also a property. Just like what the word means, it is also a property. The only difference between intellectual property and real property is that intellectual property is a creation of mind. The other property, like a chair or a table or your land or your house, is something that is tangible property, but intellectual property rights is an intangible asset. And as far as businesses are concerned, it is something that can generate value for you. So but just like real property or real estate or your house or your piece of land, you have to also develop your intellectual property right. What do you do when you have a piece of land, or what do you do when you have a house? You will maintain that house, right? You will develop it. You will probably create a fence around it to make sure that nobody else trespasses onto it. You will maintain it well, so that maybe you can lease it out and get money out of that lease. So just like that, just like how you maintain your real estate or your real property, your intellectual property also has to be maintained, it has to be developed, it has to be protected, so that it can realize value for you. Otherwise, it is just a piece of paper, it doesn't realize value for you. So to realize value, intellectual property also has to be protected and maintained. Next slide, please. Now, what is the significance of intellectual property, right? Now, I believe all of you, I always believe in startups. I have worked with a lot of startups, so I am very passionate about protecting intellectual property rights of startups. So I assume all of you also have that in you to start of your own businesses or being entrepreneurs in future. So, what is the importance of intellectual property rights for entrepreneurs? Any idea? The importance of IP lies in the fact that if you have an IP, if you have an intellectual property, if you don't protect it, you may lose it to others. Somebody else may get a protection for it, and you may lose your right to protect your or realize the value for your intellectual property right. Another important factor that you need to be aware in terms of using intellectual property right is that you may be unknowingly, when you're running a business, you may be unknowingly infringing somebody else's intellectual property right. So it is very important, which can land you in court cases or litigations or whatever. So it's always important that you are not only aware of your intellectual property right, but you're also aware of others' intellectual property right, so that you don't enter into a potential infringement. And as as lawyers, we always say that ignorance of law is not an excuse. If you do not know the law, that's not an excuse. So you should always be aware of the laws that protect intellectual property rights. Next slide, please. Okay, so it's very important. So given this background, it is very important that any business, be it a business or even if it's for a university or a college where intellectual property is being generated, it is very important that you invest your time and your effort in protecting your intellectual property. And as far as businesses are concerned, the more and more you protect your intellectual property right, the more protected your intellectual property portfolio is, it makes it attractive to investors, and also it gives you a credibility as well as competitive advantage over your competitors in the market or your peers in the market. So all these makes it very important that you take proactive steps to protect your ideas and intellectual property as soon as they are generated. So the fact that you have an because any intellectual property always starts from an idea. So the fact that you have an idea in mind does not necessarily help you. If you have an idea in mind, the idea has to be translated into something that is of value, and that has to be protected. Only if it is proactively protected will it generate value for you. Next slide, please. So now let's quickly look at what are the different types of intellectual property rights. Now there are different types of intellectual property rights. We will quickly discuss all these in detail, and then we will have an interactive session after that also. So these are the different kinds of intellectual property rights: trademarks, industrial designs, patents, copyrights, geographical indications, and trade secrets. Next slide, please. Okay, now where do we protect these intellectual property rights? So if you have a trademark, or if you have a patent, or if you have a copyright, how do you protect it? You protect your intellectual property right by registering it before the Government of India intellectual property offices. Now, which are the Government of India intellectual property offices? For trademarks, you can register your trademarks in any one of the trademark offices or trademark registries that are situated in Chennai, Mumbai, Delhi, Kolkata, or Ahmedabad. For patents, you can file your patents in any one of the patent offices, the Government of India patent offices in Delhi, Mumbai, Chennai, or Kolkata. Copyright office, there's only one copyright office in India where you can register your copyright, which is in Delhi. The designs office, there's only one design office in India or designs registry in India, which is in Kolkata. And for geographical indications, you only have the option of filing it before the geographical indications registry, which is in Chennai. So the trademark office, the patent office, the designs office, and the geographical indications registry, all of these come under the Controller General of Patents, Designs, and Trademarks, which sits in Mumbai as of now. And all of these come under the Department of Industry and Commerce. So this is where we actually prepare and file our applications for registration of your different kinds of intellectual property rights. This is just for your information. Next slide, please. Okay, now let's discuss what is a trademark. Now, all of these images that you see on the screen are very familiar to you. What are these? These are either words there are some words like, let's say, for example, Mercedes-Benz or Pepsi. These are words. A trademark can also be a logo. Let's say, for example, if you see the three-pointed star symbol on a car, you will immediately know that the car comes from Mercedes-Benz, right? So logos can also be trademarks. Trademarks can also be shape. For example, the shape of the Hershey's chocolate, that is also a trademark. It can be a tagline. Let's say, for example, when the moment you hear, let's say, I am loving it, or you know that, okay, you're talking about McDonald's burger, right? Or just do it. That's the tagline of Nike. So all of these are trademarks. It can also be a packaging. It can be a symbol. It can be a signature. It can be just a numeral, or it can even be a combination of all of these. All of these can be considered as trademarks. Next, please. Next slide, please. So these are all traditional trademarks, that is logos, symbols, words, which immediately help you recognize a particular product or a service. Now, apart from these traditional categories of trademarks, there are some categories of trademarks which are called non-traditional trademarks or non-conventional trademarks. A classic example of non-conventional trademark is the sound trademark of MGM Studios. When you watch the Tom and Jerry cartoon, you would have listened to or watched the advertisement of MGM Studios where there is a roaring lion. That sound of the roaring lion is a registered trademark of MGM Studios. The sound can also, because the sound is so associated, the moment you hear the sound, you know that it is MGM Studios advertisement. So sound can also be a trademark. Color can be a registered trademark belonging to a particular party. A classic example is the red color sole of Christian Louboutin shoes. It's a luxury shoemaker. Their shoes has a unique red color on the sole of the shoes. So that can be used only by Christian Louboutin shoes, because that is a registered trademark. Another example of sound trademark is the Netflix tick sound. So when you switch on Netflix, I'm sure you must have all listened to the tadam sound that comes when you switch on Netflix, right? That sound is a registered trademark of Netflix. Shape, the shape of Hershey's chocolate. Movement or motion can also be a registered trademark. A classic example of movement trademark or motion trademark is the old Nokia phone. When you switch on the Nokia phone, you see an image of two hands coming together to form a handshake, right? That movement is a registered trademark. The upward movement of the Lamborghini cars, the doors of the Lamborghini cars, is also a registered trademark. So movements can also be registered as trademarks. Next slide, please. So these are all non-conventional trademarks or non-traditional trademarks, which are also eligible for protection as trademarks. Now, there's a lot of difference between, a lot of people confuse between trademark and trade name or business name. So how do you identify a trademark from a trade name? Trade name is a name of your business or the name of your company. An example would be Anand Milk Union Limited. That is the name of the company that manufactures Amul. So Anand Milk Union Limited would be your corporate name or your business name or your trade name, but not your trademark. But Amul would be Amul, or Taste of India would be considered your brand name or your trademark. So there's a difference between trademark and trade name. A trade name can also become your trademark, but these two has to be distinguished from one another. Next slide, please. So what is the function of a trademark? Why do you need trademarks? Why do you need to protect your trademarks? The reason is that, see, when you, let's say, for example, you're going to a supermarket, right? And how do you choose? And you want to buy a brand of chocolate. How do you choose the chocolate that you want to buy? You choose it with the help of the name, right? The name of the chocolate. You want to buy Nestle. You want to buy Kit Kat. So how do you choose Kit Kat out of the whole lot of things that you see on the shelf? You take the trade, or you take the product based on the packaging, right? The packaging, or the moment you see the Kit Kat packaging or the name Kit Kat, you know that it comes from Nestle. So that is how. So the primary function of a trademark is that it indicates a source of the product. When you hear or when you see the Nestle name, or when you see the Kit Kat name, you know that it is coming from Nestle. So it's a Swiss chocolate, or it's made by Nestle. So trademarks are source indicators. When you see a car with the three-pointed star symbol, you immediately know that, okay, this car is manufactured by Mercedes. So trademarks are source indicators. The moment you see a trademark, which can be a logo, a label, or a product packaging, or a color combination, or a color scheme, you identify the source of that particular product. Trademarks also assure you the quality, right? So the moment you see let's say a Lindt chocolate, you know that, okay, the chocolate comes with a certain level of quality that is assured with it. It also is an indicator of the goodwill of the business, and it also indicates the awareness that the brand has amongst the general public. Next slide. So now coming to choosing of trademark. So how important it is to choose a trademark. Now, and how do you choose a trademark? Are all trademarks eligible for protection? No. So when you choose a trademark for your business, whether it is for your product or your service, you have to be very careful. You know, not all trademarks are eligible for protection, or not all trademarks are eligible for registration. So when you choose a trademark, also you need to be very careful. There are certain parameters that you need to be aware of when you're choosing a trademark for your business. So here is a distinctiveness spectrum that you can see on the screen, which will help you identify or choose the right kind of trademark. So on the right-hand side of the spectrum, that is towards the right-hand side, you will see trademarks that are fanciful. Fanciful trademarks in the Varnale, trademarks that are coined words or invented words, which do not have a dictionary meaning. Those type of trademarks are considered highly distinctive and eligible for the maximum level of protection. These are brands that you created on your own. They don't have a dictionary meaning. An example would be KitKat or Xerox or Haagen-Dazs. These trademarks have no, or these words have no dictionary meaning. So, and because they don't have a dictionary meaning, and because they are invented by you yourself, it is eligible. It is considered the most distinctive category of trademarks and eligible for protection. Now, the next category of trademarks are called arbitrary trademarks. Now, what are arbitrary trademarks? Arbitrary trademarks are words that have a dictionary meaning, but they do not indicate, or they don't have anything to do with the product or the services on which the trademark is used. A classic example is Apple, right? Apple is a fruit, but what is Apple? The brand name of Apple is a brand for mobile phones and computers, right? So, which has absolutely no connection. So, Apple as a fruit has no link to mobiles or computers. So, those kinds of trademarks are called arbitrary trademarks, which have a dictionary meaning, but they have nothing to do with the product or the service on which it is used. So, that kind of trademark, those kind of trademarks are also eligible for registration and eligible for protection. Now, the third category of trademarks is called suggestive trademarks. Suggestive trademarks are trademarks which suggest, which are not directly describing, which do not directly indicate the nature of the product. But when you hear the product, you know that, okay, this could be something like this. An example I would say would be Ujala, right? Ujala, when you hear the word Ujala, you might think that, okay, this could be something that, that is a whitening preparation, or that would make things white or whiter, or it could be a bleach related, something related to bleach because it says Ujala. So those are suggestive trademarks. The trademark may suggest the nature of the product. The last two categories of trademarks are brands that you should ideally avoid from choosing for your business. One is descriptive trademarks. Those are trademarks which are highly descriptive, which very clearly describe the nature of your product. For example, American Airlines, or let's say carpet cleaning company for carpet cleaning services, right? Those are directly describing. When you, or Make My Trip, for example, Make My Trip is also a directly describing trademark. When you hear the trademark itself, you know that, okay, they're a tour operator, or they help you book your travel tickets or something like that. So it is a directly descriptive trademark. So the last two categories of trademarks are trademarks that you should ideally avoid from using for your business or your product or your service. The first three categories, rather the first two categories of trademarks, the trademarks that you should ideally choose if you intend to start a business, or if you want to name your product or your service. Next slide, please. So now that you have chosen a trademark, you know how to choose your trademark, and you have chosen a good name for your business. What do you do next? You need to find out if that particular trademark that you have chosen is already, in use by someone, or is it already registered by somebody else. So it's very important that you first do a trademark search. a search in the records of the Indian Trademark Office to see whether your trademark is eligible for registration or your trademark is already taken by somebody else, already applied for registration, already registered by somebody else. So this is an exercise that can be undertaken, that can be done to make sure it not only helps you get a registration, it also makes sure that you are not infringing on somebody else's rights, right? So let's say, for example, you choose a very catchy name, but what if the trademark is already registered by somebody else? Then the moment you launch the product, you may be issued with a legal notice saying that you're infringing on somebody else's rights. So it's very important that you do a proper trademark search to make sure that your trademark or the brand name that you have chosen is not already registered or not already applied for registration by somebody else. And once you clear the trademark search, the next step is you file an application. And where do you file the application? Like I said earlier, in one of the 5 trademark offices in India. And if you are in South India, if the applicant is anywhere in South India, then the appropriate jurisdiction is with the Chennai Trademark Office. So you file an application with the Chennai Trademark Office. The office will allot a number to your application. Then the office will proceed to examine your application, where the office will search its own database and see if there are any similar trademarks on record. Then they will not allow registration for your trademark. The trademark office will also, the examiner will also see if your trademark is a directly descriptive trademark, or if it's a common name or a generic name, then also it is not eligible for registration. So that is when the earlier slide comes into play, the distinctiveness spectrum. So if you choose a common name, obviously it will be objected. But if you choose a very distinctive name that is, coined by you or invented by you, then it will not be objected on those grounds. So after examination, the trademark office will give you a report. If the report is clear, then your trademark will proceed to publication. Publication in an official gazette called the Trademarks Journal. Now, if it is objected, the objections are sustained, then there will be a hearing. Your lawyer will attend the hearing on your behalf. And after hearing, if it is an acceptance order, it will be published in the official gazette called the Trademarks Journal. If it is not accepted, then there will be a refusal order. Your application will be refused to registration. So if accepted, your trademark will be published, and then the idea of publishing trademarks is to basically let third parties know, or the public know, that okay, somebody has applied for registration of this trademark, so that if the public has an objection, if the public has a concern with that mark proceeding to registration, the public will have an opportunity to file an opposition against that trademark registration. And if there are no opposition only, your trademark will proceed to registration. So this is the process for registering a trademark in India. Next slide, please. So I'm sure all of you must have seen this marking, right? On certain products, you will see TM. On certain products, you will, certain packaging, you may see the R inside a circle symbol. What do these indicate? R inside a circle indicates that it is a registered trademark. Somebody has applied for and got registration for that trademark. The owner, rather, has applied for and got a registration for that trademark. So you can use the R inside the circle symbol only if your trademark is a registered trademark. If it's not registered, you cannot use that symbol. And if it's pending registration, or if it is unregistered, you can use the TM symbol. The TM symbol only indicates that it is my trademark, that is all, or it's the owner's trademark. It does not it does not mean that it is a registered trademark. And what is the validity of a registered trademark? If you manage to get a registration for your trademark, your protection is valid for 10 years. And the 10 years starts from the date of registration or date of filing of your application. And every 10th year, you can keep renewing the registration for the next 10 years. Which means that you can hold perpetual rights in a trademark. 10th year renew, you can hold rights in a trademark perpetually. That is how it is different from the other intellectual property rights. Trademark rights are perpetual. You can keep renewing and you can keep owning the registration of your trademark for a long period of time. And trademark registrations are territorial. And what do you mean by territorial? Territorial means that your protection is limited to the territory where it is registered. So if you register in India, your trademark is protected only within India. If you want to protect your trademark in a foreign country, you have to register your trademark in that country. Next slide, please. In another remedy, what is a remedy? What is the advantage of registering a trademark? If you have a registered trademark, if somebody else misuses your trademark, you have an option for filing a civil suit for infringement and claim damages and injunction against the person who is misusing or violating your registered trademark, right? But if you don't have a registered trademark, then your option of challenging a misuser or somebody violating your trademark rights is only by filing a suit for passing off. So difference between passing off and infringement is that in an infringement suit, the burden of proof is on in lawyers' language, the burden of proof is on the defendant to prove that I have not violated my rights, because prima facie case is in favor of the plaintiff. But in passing off, because you don't have a registered trademark, the burden of proof is on the plaintiff to prove that the party has misused my trademark, it has caused confusion among the public, he is misleading the public and all that. So the burden of proof is higher in case of passing off. So that is why it becomes very important to register your trademark, so that if there is an instance of misuse or instance of violation of your right, you can straight away file a suit for infringement of a registered trademark. Next slide, please. Yeah, this is a very classic case. The first one that you see there is a classic case of trademark infringement where VIP came up with a brand of underwear which is called Benz, and they used an image on their product packaging which very much resembled the three-pointed star symbol of Mercedes. Now these two products are entirely different, right? One is a brand of clothing or undergarment, and the other one is a car. But still, the court held that VIP was infringing on Mercedes-Benz's trademark and ordered VIP to stop using this particular name Benz, as well as the image of which resembled the three-pointed star symbol. Another example of infringement where somebody has very clearly copied not only the name Alpenliebe, you can hardly make out the difference between the two, right? The one on the left is the actual trademark Alpenliebe, and the one on the right is a very closely similar trademark, a very clear case of counterfeit or trademark infringement, where not only the name has been copied, a very similar name is written in a very similar way, the packaging has also been copied, the color scheme has been copied, all of these have been copied, and it's a very clear case of trademark infringement. Next slide, please. Any doubts on trademarks? Any questions? I'm asking this so that I can stop talking for some time. Any doubts? Anyone? Sheila? Shall we move on to copyrights then?
Yes, nice.
Okay. So I'll move on to copyrights then. So copyright is a next category of intellectual property, right? You understood what trademark is, right? Trademark is a brand name. The easiest way to explain trademark is a brand name that is used to indicate or indicate your product or a service that you are manufacturing or marketing. That is the easiest way to define a trademark. What is copyright? Copyright is another category of intellectual property right. Copyright is the exclusive right that is granted to an author or a composer of a work. And what is the right? It gives you the absolute right to publish, print, reproduce, or sell the copies of the original work for a certain period of time. So what has copyright? To enjoy copyright, you need to own some work. You have to be the author or composer of a work. And what are these categories of works over which there are copyright? We'll discuss in the next slide, please. Okay, so what are the rights? What are the categories of works that have copyright in them? One is literary, dramatic, or musical works. Let's say, for example, you've written a piece of poem, or you have composed a music. Your musical notations are eligible for copyright protection. A book that you have written, an article that you have published, all these are eligible for copyright because you have composed the work, you have authored the work, so you have created something, right? And that creativity has to be either in literary format where it is a writing, or it can be a musical work, or it can be an artistic work. For example, you have designed a logo, or you have designed a caricature, or you've drawn a painting, or you've you've created a cartoon image, all of these are eligible for protection as copyright as an artistic work. Computer programs also in India are categorized under copyright eligible or copyright protection eligible categories of work. Computer programs per se, for example, just the coding or just the algorithms are categorized as copyright eligible works in India. Cinematographic works are also eligible for protection under copyright. Sound recording. So if you when you're listening to a song, the sound recording of that song is also eligible for protection as copyrights. So these are categories of works that are eligible for protection as copyrights. Now, what is the difference between copyright and the other intellectual property rights is that copyright is a sui generis right. Sui generis right means a right that is automatically created. You don't need to register your copyright to get protection for a copyright, because copyright is automatically created. The moment your idea, copyright also starts with an idea, right? So the moment your idea is transferred or copied into a tangible medium, so let's say you have a story in mind, that story is written on a piece of paper or on a computer. Immediately your copyright is there. You own copyright over that. So when the moment the idea is transformed or copied into a tangible medium, copyright is automatic. So copyright is a sui generic right, a right that is automatically created the moment the work is created and transformed into a tangible medium. Next slide, please. And what does copyright protect? Copyright does not protect the idea. What copyright protects is the expression of your idea. Let's say, for example, how do I explain this? Let's say there's a cricket match happening in a stadium, and two reporters are going to watch the match, and they are going to cover that match in an article, right? So their idea is the same. Let's say it's an India-Pakistan match and one of them wins. So the basic idea behind the match is the same. But what they write is the expression of their idea. What they write or what they bring out into the paper on a piece of paper is their expression of idea. So each will have their own copyright over the expression of their idea. You cannot say that one is a copy of the other. So what copyright protects or prevents is copying somebody else's content, right? So if I use my own, so the two reporters are covering the same event, and as long as one is not a copy of the other, each person's original content, original writing will be eligible for copyright protection. The underlying idea is the same, right? But what they express it, the way they express it is different, because it is each one's originality or original content, and each one of them is eligible for protection as a copyright. So the fundamental aspect of copyright protection is that your work should be original. It should not be a copy of the other. It need not be new. It need not be new. It only needs to be original. It has to be your original work. And so what is protected is the author's original creative expression that is protected, not the idea behind his expression, the actual creative expression of the author. So that is why we always say that there's no copyright in an idea. There's no protection for an idea. The idea, when the idea transforms into something, some product or a process or or let's say a book or a poem, then it becomes eligible for protection. So if it's a literary content, your idea becomes eligible for copyright. If it's a musical work that is created out of your idea, then also it is eligible for protection as copyright. Next slide, please. So like I said earlier, copyright being a sui generis right, it is not compulsory to register copyright. It is an automatic right. So you need not necessarily register your copyright, but still it is always advisable to register copyright, so that when you get a registration for copyright from the Copyright Office, law is giving you a statutory right, saying that this is your original work. So you can file an application before the Copyright Office in New Delhi. Your application will be examined, and if there are no objections, it will be registered. So when you see the C inside circle symbol, right, this is something that you commonly see when you read books or on websites and all. You see the C inside a circle symbol. What does that mean? That does not necessarily mean that it is a registered copyright. It just means that it is somebody's copyright. Because he has created it, he owns the copyright on that work. And this is a copyright notice. So this is a common thing that people do. People put copyright notices because, if you don't register your copyright, how do you indicate to the public that it is my copyright or this is my work and nobody can copy it? So it is by giving a copyright notice. So even if your work is not registered also, you can put the copyright notice on your works, which is, just copyright C inside a circle with a date and all rights reserved, just to indicate that this belongs to me, the copyright belongs to me, and I am the author of this particular work. Next slide, please. And what is the validity of a copyright? What was the validity of a trademark? Trademark registration is valid for 10 years, right? And it can be perpetually renewed. What about copyright? Copyright, the validity depends on either the date of publication or the date of death of the author. So if it's an original literary, dramatic, musical work or an artistic work, the validity of copyright is 60 years from the date of death of the author. So this has nothing to do with the registration, the date of registration. So irrespective of whether you register your copyright or not registered, the validity of a copyright is 60 years. For literary works, musical works and artistic works is 60 years from the date of death of the author. And what about other categories of works like cinematographic films, photographs, etc.? It is 60 years from the date on which it is published. And what are the remedies if somebody misuses your or copies your work? You can file a civil suit for injunction against the party, or copyright infringement is also a criminal offense. So a criminal case can also be filed against somebody who is infringing your copyright. And to file a suit for copyright infringement, unlike trademark, you don't need to register your copyright. Even if it is an unregistered copyright also, you can initiate a suit for copyright infringement. Next slide, please. Okay, now the next category of intellectual property right, which is design. Now, what is the difference between a design and a patent? That also is something that we will discuss now. Design is an intellectual property right for the external shape or configuration or for some eye-appealing aesthetic feature of an article, which is new. So that shape or configuration or the feature of the article should be something that is absolutely new, and it should be a part of that article. So let's say, for example, you've designed a new chair, and the features or the shape of the chair is very unique, very different from what is already existing in the market. Then you're eligible for protection as of your design, protection of the shape of your chair as a design, and you can register your design so that nobody else can use the same design for a chair. Next slide, please. So what are the categories of designs that are eligible for design registration? Any article, the design of any article. It can be the shape of a car, it can be the design of a chair, a tube light or a bulb, some design on a tile, anything, any article whose shape is new can be registered as a design. Next slide, please. And what is the criteria for design? Are all designs eligible for registration? No. The criteria for design registration is as stringent as patent registration. So to be eligible for design registration, your design that you have invented should be absolutely new. It should not be published anywhere in the world. If you yourself publish your invention or your design also, it is not eligible for design registration. So absolute newness or absolute novelty is a criteria for design registration. It should not have been published anywhere in the world. And it should be applied by an industrial process. And your shape, what is protected is not the function of the design. What is protected is only the shape or the eye-appealing features of that particular design, not the function. So if you have designed a product and the functional aspect of it is not covered by design, only the shape of that article is covered by design registration. If the shape is new, if the configuration or the shape of that particular article is new and not disclosed anywhere to the public, anywhere in the world, then you're eligible for design registration. Next slide, please. And how do you register designs and where do you file it? As discussed earlier, we can file design applications for registration of your design before the designs office, which is in Calcutta. There's only one designs office, which is in Calcutta, where you can file your application and get a registration for your design. So you file an application, The designs office will examine the application. They have to be convinced that your design is not published anywhere. They'll check their database and everything. And if your design is absolutely new and novel, then they will issue a registration certificate. And what is the validity of a registered design? The registered design is valid only for 10 years and which can be renewed for a further period of 5 years. After that, your registered design goes into public domain, which means anybody can use it. So it is a limited time period. So like copyright, design registration has a limited time period for protection. Your protection is the maximum amount of protection time period that you can, you're eligible for protection is only 15 years, after which anyone can use a design. But within that 15 years, you will get the exclusive right to use that, apply that design to the product for which it is registered. Next slide, please. Now coming to the next type of intellectual property right, that is patent. Now what is a patent? Patent is intellectual property right for invention. So if you have an invention, so as opposed to a design or a shape or an artistic work or a literary work, patent is or a brand name or a logo. A patent is the intellectual property right for an invention. So if you invent something, and if that invention is eligible for registration as a patent, you can apply and get a registration for a patent, registration as a patent for your invention. And what do you get by getting a patent for an invention? You get the absolute monopolistic right to use that particular invention. Nobody else can misuse or can use that invention if you have a patent for it. And it is a statutory right. So unlike copyright or trademark, patent is a statutory right. And what do you mean by statutory right? The statutory right is a right that is granted by law, which means your patent or your invention is a patent, can be called a patent or is protected only if you get a grant for it, or only if it is registered. So an unregistered patent has no protection. If you don't file it also, there is no protection. So a patent is protected only when there is a granted patent, only when there is an invention is protected, only when there is a patent granted to it. Until a patent is granted, there is absolutely no protection for a patent. Trademark trademark and copyright unregistered we have rights, right? But patent for patents and designs, you're eligible for protection only if there is a patent granted or a design registered for that particular article. And like trademarks and designs, patent is also a territorial right. So your protection is limited to the territory where your patent is filed and registered. So if your patent is filed and your invention is filed as a patent and registered in India, your protection or your exclusive rights or your monopolistic rights are limited to the territory of India. Next slide, please. So are all inventions eligible for patents? No. You cannot say that all your inventions are eligible for patent. So for an invention to be eligible for patent, it has to satisfy certain criteria. Now, the first and foremost criteria is the same as designs. That is, your invention has to be absolutely new. That is, the invention should not be disclosed anywhere in the world by anyone. So if you yourself disclose it to the public also, your invention will not be eligible for patent. So your application will have to be filed before you publish the invention. So if you're working on something, working on a product or a device which has a functionality which is new, which you think is eligible for a patent, I would always recommend that you approach your faculty or your seniors or KCST for an opinion or for a legal opinion as to whether this is eligible for protection as a patent. And if it is eligible for protection as a patent or a design, always make an application for registration of the design or a patent and only then publish your invention. Because if you publish your invention or your design, then you're not eligible for getting a registration as a patent or a design. So publication can be done only after your application is filed. At least your patent has to be filed before you publish your invention. The reason is that absolute novelty or newness is the criteria for patent eligibility for patent. So if you publish your invention at the time of examination of your patent, if the patent examiner finds out that before the date of your application you have published your invention, he can discard or he can refuse the registration of your patent on ground that it is not a new invention, it is not new or novel as on the date of filing the application. Now, the second criteria, very important criteria for patentability is inventive step or non-obviousness of a patent. Now, this is a very subjective criteria, rather difficult to convince the examiner also if it is raised. Now, what do you mean by inventive step? Inventive step means that your invention should not be, what do you call, should not be an obvious invention, or should not be obvious to somebody that is skilled in that particular field. Let's say, for example, if your invention is something in the field of physics or astrophysics, I may think that is, I have absolutely zero background in, I have zero background in astrophysics. So I may think that this is a very fantastic invention, but I am not the person who should judge it. A person skilled in that field should not be able to derive that invention from what is already existent there. So if a person who is skilled in the field thinks that, oh, this is something that I have also thought of, then it becomes ineligible. Then it becomes ineligible for a patent. So your invention should not be obvious to a person who is skilled in that particular field. So when I say obvious, it does not mean simple. So simple inventions can be patented if it is not obvious. So simplicity and obviousness should not be confused. Simplicity is different from obviousness. If it is obvious to a person that is skilled in that particular field or technology, then it becomes ineligible for registration as a patent. Now, the final criteria is utility. I'm sorry, utility or industrial applicability of your invention. So your invention to be eligible for a patent should have some utility, some use in commerce, or some industrial applicability. Only then will it be eligible for a patent or grant as a patent. Now, this can also be considered as workability. So when you file a workability of an invention, now what happens when you file a patent application? How do you file a patent application? Everything is in paper. You don't have the opportunity to take your invention. Let's say if your invention is a machine, or a rocket, let's say, for example, you don't have an option to take the prototype of the product or the machine or the rocket to the examiner and show him that this will work, right? So how do you prove that it will work? You have to, your invention or your description of your invention should be very clear. The description of the invention should be so clear that by just reading it and looking at the figures, the examiner should be convinced that it will work the way you claim it will work, right? So that is very important. So utility or workability of your invention is also very important. It is very important that you're able to convince the examiner that your invention will work the way you claim it will work. So drafting, which is why drafting of patent specifications is very important, because you cannot just give a technical write-up and submit it to the patent office and think that it will be eligible for patent protection. You should be able to convince the examiner just by reading that paper or your figures and everything, or your process flow and everything, that the invention will work and give the desired results that you claim in the application. Next slide, please. So apart from these criteria, the three important criteria, there are certain categories of inventions which are already categorized as non-patentable inventions in the Patents Act, which is explained in section 3 of the Patents Act. I don't think I'll go into details of all these sections, because I believe these will be covered in the sessions on patents that are taken in the coming 2 days. Correct me if I am wrong, Shafiq sir. You're going to have very detailed sessions on patents, right? Tomorrow and day after. So can I skip these slides where I discuss the inventions that are not patentable, etc.? Yeah, I can move on to the next slide, please. So like I said earlier, apart from the three important criteria, there are several categories of inventions that are not eligible for patent, that are considered inherently non-patentable under Section 3 of the Patents Act. So when you file an application for registration or grant of a patent, you have to also make sure that your invention does not fall under any of the non-patentable categories of inventions under Section 3 of the Patents Act. Next slide, please. Now, this is a very important slide. Some general information, some do's and don'ts for inventors. or prospective inventors who are working on some research or development, and who feel that there will be something that is potentially patentable in future. So these are things that you should always keep in mind if you're looking at patenting or considering patent as a future project. One is always maintain records of your research, because these research records become very valuable information for patent attorneys to draft the specification of your patent. So all research should be properly maintained so that you can share it with your patent attorney and help the attorney draft the specification for you. Second point, something that we already discussed, if you're looking at patenting or filing a design application, do not publish your invention before you file the application. Always file a patent application and then publish your invention. There is no objection to secret working of your invention in a lab or anything, but publication or any publication which is available to the public would be a potential bar to the impediment to the registration of your patent. And very important, always conduct a patent search. See, patent is a very expensive affair. It takes a lot of time and effort. So before you invest a lot of time into preparing and filing application, paying your patent attorney, and filing an application and all of that, it is always important that you do a patent prior art search, a proper patent search, to find out whether your invention is eligible for patent, whether it is already published anywhere in the world. Now, I understand that there will be a very detailed session on patent prior art searches tomorrow. So please listen to that session so that you understand what is the importance of patent prior art searches and why is it being done before you file a patent application. The idea of doing a patent prior art search is to assess the first criteria, the number one criteria of patent eligibility, which is novelty. Is your invention eligible for patent? Is it published anywhere in the world in any other? The publication can be in let's say another scientific journal. It can be in another patent document filed in some other country also. All those can be a bar to the registration of your a patent. So patent prior art searches are very critical before you file a patent application. And finally, always keep in mind that in patents, because it is a statutory right, it is always the first to file that has priority. So if I have invented something and I have not filed a patent application, I have kept it with me, I have been doing a lot of research and I file it after 2 years. But in between, just 2 days before I file my application, if somebody else files an application for the same patent, it is that person who will get priority over me because he filed the application first. So in patent, first to file has always as priority, and for the same reason, it is always advisable to file your patent application as early as possible. In fact, you don't need to wait for your entire invention to be ready or your prototype to be ready to file a patent application. Even, as soon as your idea has taken a definite shape, your research has reached probably, 3/4 of its stage, and you know how the product is going to develop into. At that stage, you can file a patent application so that you can save on time, right? Because the more you delay filing your patent application, the chances of losing novelty are there. So always file your patent application as early as possible. And then, file it with a provisional specification followed by a complete specification, all of which will be discussed in the sessions tomorrow. So I'm not going into those details. And finally, like I said earlier, it is always important that you choose a patent attorney to draft the specification, because a patent specification is a techno-legal document. So there's a lot of, it has to be drafted with a lot of care. The reason being that, like I said earlier, it's not possible for you to bring your product to the examiner and show him that it will work. You should be able to convince him with the write-up, with the figures, that it will work and give the desired result. So the way you draft the patent specification is also important. And so it's equally important that you choose someone, a patent agent or a patent attorney who's skilled in the field to be able to draft a proper specification. Next slide, please. So like I said earlier, patent is a territorial right? So if you file a patent in India, your invention is protected only within the territory of India. So what do you do if you want to protect your invention in other countries? Obviously, you have to file and register your patent in each of those countries. And for that, there is something called a patent cooperation treaty. I am not going into the details of the patent cooperation treaty because my colleague who is taking the session on 20th will explain that, PCT and how you file patent applications in foreign countries in detail. Next slide, please. So the next category, so I hope you have got an idea of what patents are. Let's move on to the next intellectual property right, which is geographical indications. Geographical indications or GIs. I'm sure all of you must have heard of GIs. What is a GI? GI is a brand name or the name of a particular product which has some quality that is attributable to the origin of that particular product or the territory from where that product originates. It can be an agricultural product, it can be a natural product, it can be a manufactured product, it can be a handicraft. But what is the uniqueness? There's the product should have some uniqueness, some quality that distinguishes it from other products, and that quality is attributed to the geography or the place where that product originates. Next slide, please. So I'm sure all of you are familiar with all these things. Classic examples of geographical indications: champagne or Scotch whiskey. All whiskeys are not Scotch whiskies. You can call a whiskey a Scotch whiskey only if the whiskey comes from Scotland. Similarly, champagne. Champagne is actually a particular type of sparkling wine that is made from grapes that comes from the Champagne region in France. So you can call a sparkling wine a champagne only if the grapes that is used to make that particular wine comes from Champagne region of France. And because and the grapes have certain qualities that is attributable to that particular region. Pashmina, for example. Pashmina is a very soft wool that is taken from the undercoat of a particular variety of goat or sheep that is seen only in the high altitudes of Leh Ladakh region in Kashmir. So it is that particular temperature, the altitude of that region that gives the wool a certain characteristics which is attributable to the particular product it is made into. So Kashmir Pashmina, Kanjipuram silk, as far as Namada Kerala is concerned, Vazhakulam pineapple, Marayur Sharkara, all these are examples of GI products or products that are GI tagged registered GIs, where the products have some uniqueness or some quality that is attributable or that is because of the geography or because of the place from where that originates. Next slide, please. And what is GIs? Just like other GIs, just like the other intellectual property rights, GIs can also be registered, right? But who can own a GI? GI cannot be owned by a company. For example, a patent can be owned by a company or an individual, but GI is not a individualistic right. GI is a community right. So GI can be owned only by the community or the group of people that manufactures or produces that article. So, and what is the importance or what is the advantage of getting a GI registered? When a GI is registered, as consumers, we are ensured that you don't get fake products on the market, right? So when I go to a supermarket and I buy Marayur Sharkara, I know that it is manufactured or it is made in Marayur. It comes from that particular region. So it protects consumers from fake products. It also protects the interests of producers, actual producers, by preventing counterfeits and unfair competition. So the whole idea of registering a GI is to promote the economic prosperity of producers. Because if you look at most of the GIs, not talking about foreign GIs, but the local GIs, the Indian geographical indications, the producers are all in the unorganized sector. So the whole idea of registering GIs is to make sure that their interests are protected. So, and nobody copies that GI, nobody uses that name on a non-GI product. Next slide, please. Okay, now if we have the time, are we running out of time? Sir, shall I continue?
Yeah, sure, madam. Sure, madam.
Okay, thanks.
Okay.
So now we discussed, different types of intellectual property rights, right? So we discussed patents, trademarks, copyrights, designs. So in all these cases, we talked about registration, right? We talked about registration where you prepare and file an application for protection of your design or protection of your patent. So you've invented something, you have to disclose it to the government so as to get a protection for it, right? Now, let's say, for example, you have invented something, but you don't want to disclose it. Let's say, for example, it is a recipe. It is some very critical information that you don't want public to know. You want to keep it a secret. How do you protect it? You can protect it as a trade secret. What is the, so trade secret basically is any information that you want to use in business, but you don't want to disclose it. You want to keep it a secret from others. right? But if you want to protect it as a patent or a copyright or a design, you have to publish it. You have to give it to the government, right? But if you don't want to do that, the only option to protect it is by registering it as a trade secret. Now, is there an option to register a trade secret? No, there is no protection. There is no law that will protect you or that will help you register a trade secret and make sure that the secrecy is maintained. No. The only way you can protect your secrecy or protect your trade secret is by making sure that you take all the necessary steps to keep it a trade secret. So what happens if somebody misuses your trade secrets? You have to always make sure that if you have to disclose your confidential information or your trade secret to somebody else, always disclose it under a confidentiality agreement, so that if he misuses that information, you can at least file a case for breach of agreement. Otherwise, there is no provision to register a trade secret. It is not registrable. It is a secret as long as you keep it a secret. Next slide, please. And how do companies maintain confidentiality? Are you aware of any trade secrets? Anything that you can think of trade secrets? Google's algorithm is a search algorithm is a trade secret. Another example of trade secret is Coca-Cola's recipe was a trade secret, not anymore. Another example of trade secret is the formula that New York Times bestseller, everybody would have heard of. Our using the formula to choose the bestseller among the books. That is also a trade secret that is not known to anyone. A lot of companies in Kerala, especially masalas, their combinations, their recipes are kept a trade secret. How do they keep it a trade secret? The combination or the recipe is known only to a very few people within the company. It could be just one or two people, right? And when it has to be disclosed to someone, let's say, for example, if it has to be manufactured, then obviously it has to be disclosed to the person who is manufacturing it or the company that is manufacturing. And in that case, it will be disclosed only under a term of confidentiality or under an agreement of confidentiality, which will ensure that the party will not disclose it to a third party. So when companies have confidential information or when companies have trade secrets, they always label that information as confidential so that they do not want public to misuse it or even their employees to misuse it, and always restrict access to databases, servers, or computer programs that have these confidential information. And companies also educate their employees to make sure that they don't divulge these confidential information. And obviously, anyone who is privy to or anyone who has knowledge or to whom a confidential information is disclosed to will always have to sign a non-disclosure agreement. So these are ways that companies protect their trade secrets. So as you can see, these are all measures that we ourselves will have to take to protect our trade secrets. There's no law particularly to register or protect your trade secrets. Next slide, please. Next slide, please. So just as, all these brand names, your copyrights and trademarks, patents and all of that, your company name, your domain names, your social media accounts are also eligible for protection as all these are intellectual property rights. If you're running a business, your domain name is also intellectual property rights. So always important that you protect your company name, you register your company name, you register your trademarks as domain names. And all of that. Your social media accounts are also, because, right now, most of the businesses happen through the internet, right? So in this era, your social media accounts are also very important. And a word of caution, always make sure that, when you use social media accounts to distribute any content, make sure that you don't source it from another website or another, because that may amount to infringement. There are a lot of cases as a lawyer. We attend to a lot of cases where, somebody has used content from someone else's website and used it onto their website. And, they have been issued with legal notices because those content on a third-party website could be copyright protected. So whether you're using your social media accounts or whether you're using your domain name or your company name, always be aware of third-party rights also, because as much as these are, your social media accounts or your internet domain names, your company names are your intellectual property rights, you should always be careful of not infringing a third party's intellectual property rights by using these intellectual property IP rights. Next slide, please. So these are some of the, so just a wrap up of what we discussed so far. These are some of the, in my experiences, the things that I have observed, as an IP practitioner for almost 19 years now. Common mistakes that, IP owners make is, one is they don't have a clear cut strategy to protect IP. See, IP is time bound. First of all, IP rights are time bound. IP rights are territorial. So if you're looking at building a portfolio of your intellectual property rights, you need to have a very clear strategy in mind. You need to be able to identify your IP, make sure that you protect them, take timely steps to protect them, make sure that you are not infringing on third-party intellectual property rights, and make sure that you renew your intellectual property rights on time. So a clear strategy is very important. As far as large businesses, small businesses, or even for universities that have a lot of, colleges that have a lot of intellectual property rights being generated, that strategy is very important. It has to be a proper strategy to create and implement the protection of your intellectual property right. The second important thing that we note is that you ignore the standard IP practices, because, as this is mostly in terms of businesses, they're always in a hurry to launch their product, find investors and all of that. IP always takes a backside, right? But it will be too late by the time they realize that, IP is as important as the other assets of the business. So having a standard IP practice is also very important for any business. Finally, the third important step is proper document foundation. A lot of times we see that, something that I've noticed in many companies is that, there's no document foundation. There'll be a lot of employees, they may not have employee agreements, they may not have confidentiality agreements with their employees. All of these can create problems in future. So having proper document foundation for your business is also very important. Confidentiality controls, obviously when you're dealing with patents, or when you're dealing with trademarks or trade secrets or whatever intellectual property rights, it's always important that you have proper confidentiality controls, proper confidentiality agreements signed with people that deal with your intellectual property rights. And finally, the most important business, do it yourself. The DIY approach to intellectual property rights. A lot of people still think that, I can file a patent on my own. I can do it, the do-it-yourself approach to IP. I will never advise filing, yes, it is something that can be tried. Search is something that can be done. But when it comes to drafting of patent specifications, of preparing design applications, choosing the right trademarks, searching for trademarks, searching for patents, searching for designs and all of that, always take, help, or take advice from a legal practitioner or somebody who's specialized in the field, so that you can start from the beginning. You can make sure that the strategy is very clear, and that you take proper steps to protect your intellectual property rights. Next slide, please. I think we've reached the end. Yeah, I think we've reached the end of the presentation. If you have any questions, please feel free to ask.
Madam.
Yeah, yes, sir.
That was a nice presentation. You have kept your energy right from the starting to the end. The same energy you have shown. And that was a very informative session. Almost 105 participants were there till 8:15. Okay, and that shows that was a very interesting session. And I have one question, that is, can you suggest some job opportunities for the students after completing BTech? What are the job opportunities in the intellectual property rights field?
For BTech students, sir, one is, there's a lot of scope for patent agents, right? In fact, a lot of patent agents that work in our office are also BTech or MTech qualified, but they need to clear the patent agent examination. So what they can do is, after their BTech, if they're interested in drafting, if they're interested in research and all of that, they can prepare for the patent agent examination. I would also advise taking a course. I mean, there are IITs, I think IIT Kharagpur offers courses for patent attorneys. That is one option that you have. Otherwise, just prepare for the patent agent examinations, because patent agent is a very lucrative job. Law firms like us hire patent agents. The reason being that, see, I am a lawyer by profession. I don't have a science background. I am a I'm an LLM, so I don't have a science background, but I deal with patents. So how do I do that? I always we need technical people in our office. So we hire people with technical background, with the clearance of a patent agent examination, who will help us with drafting of specifications. So job opportunities for BTech graduates would definitely be as patent agents, but you need to clear the patent agent exams.
Okay, thank you, ma'am. So now the floor is open for the questions. So please have your...
So you can move on to the next slide. I have some questions. If you are not asking questions, I will ask questions.
Okay.
Okay. So here's a question for you. So we have discussed that all intellectual property rights originate from an idea, right? So somebody has developed these things. What do you think is the appropriate protection for all these? A computer game or a computer program. Which IP would apply to a computer program in India?
Copyright.
Exactly. Because in India, computer programs are categorized as literary works in the Copyright Act. Similarly, in Patents Act, Section 3 specifically excludes computer programs, computer games, or computer algorithms from patentability. So Patents Act specifically says that computer games, computer programs are not patentable, and Copyright Act lists computer algorithms and softwares as literary work under the Copyright Act. So one would be copyright. The second one, you design, you have a piece of furniture and you have created a new design for a piece of furniture or a chair. What would be the eligible protection for it? It would be design, right? Because you have made a new design which is an eye appealing or aesthetic feature of the article. It can be eligible for design registration. Okay, next question, next slide, please. Just 4 or 5 questions. Okay, this I'll quickly explain. I don't want you to sit and read the whole thing. So let's say a company called Q Enterprises. Okay. They are in hospitality business in India since 1999. Their trademark is Key Residency, but they have no registration. They did not take a registration for Residency as a trademark. Another company in London, which was founded only in 2005, expanded their restaurant chain and they started a Key restaurant in India. And they filed a trademark application in 2021. So my question is, can Q Enterprises initiate trademark infringement proceeding against the London company when they launched the restaurant by the same name in India? And why? Any idea? The answer is that the Indian company cannot initiate infringement proceeding against the London company because they don't have a trademark registration. Even if they have been using this brand in India since 1999, they cannot initiate infringement proceeding because the trademark is not registered in India. The first to file the trademark is a London company. So infringement proceedings cannot be initiated, but they can initiate passing off, a suit for passing off against the company, the London company. Next slide, please. Okay, so J.R.R. Tolkien is the author of Lord of the Rings. So he died in 1973. So can I make a translation of Lord of the Rings? Is there copyright protection for this book now? What is the term for protection of copyright in a literary work, in a book? Yes, it is 60 years from the date of death of the author. So this is still covered under copyright because 60 years aayitillalo. So Lord of the Rings at a copyright ippudu is with the legal heirs of the author. Next slide, please. Okay, a cloth manufacturer wants to launch as part of his new collection a series of plain t-shirts in different shades of colors. Can that be registered as industrial design? T-shirt, plain t-shirts, but in different shades of colors. Design eligibility or no? No, because design is for the shape or configuration, color nalla. Color, there's no design registration for color. Color number disclaim registration of the design is for the shape or configuration, not for the color. Next slide, please. Okay. Just discuss that. Invention, we have invented something, right? But to file a patent, obviously, you have to give a very detailed disclosure of your invention to the patent office. But you don't want to disclose that invention to anyone. So is there any other way to protect it? How do you protect it? Yes, you can protect it as a trade secret, but other than there's no provision to register your trade secret. You have to maintain the secrecy. You have to take all the necessary steps to maintain the secrecy of your invention. That is the only way you can protect your invention if you don't want to disclose it to the government or to the public. I think there's one last question. Yeah, again, almost like the first question. What are the IP protections for A, B, C, and D? A company wishes to ensure that no one else can use their logo. Trademark and also copyright. Because logo is an artistic work, yes, logo can be registered as a trademark and you can protect it. But because logo is an artistic work, it is also eligible for copyright protection. So a singer has rendered a performance, right? And he has taken a video of his concert. So he wants to give that right to someone. What right would be covered by that? It is copyright, because the singer has got what is called a performer's right. Copyright in a category of right, a performer's right. That the singer is or a dancer or somebody who's performing something will have the exclusive right to make copies or make an audio or video recording of his performance. Our exclusive right to copyright. It is called a performer's right. That is covered by copyright. So I have discovered or I have invented a new way to process milk so that there is no fat in the products made from it. So it's a process. How can I protect it? It is a process to make a product. It is also eligible for patent. So patent covers not only product, it can also be a process to make a product. That is also eligible for patent protection, provided it is absolutely new and it is not disclosed anywhere in the world. It has to be new. So if this process is, let's say, if this process to reduce fat content in milk is already disclosed, let's say it is already disclosed in a patent application filed in China or US, then you will not be eligible for patent in India. So even if your patent is going to be filed only in India, the process has to be, or what is being claimed in your patent has to be new across the world, not just in India. The novelty has to be across the world. And finally, a company wants to invest in product packaging. So, they've designed a new packaging for, let's say, if it's a chocolate, they have designed a new packaging, a new color scheme, a new design for their product packaging. And they want to make sure that this product packaging is not copied by anyone. How do they protect it? It cannot be trade secret. It has to be trademark. It cannot be design, because design is only for the shape. The product packaging, if it's a shape, it can be a design. If the shape of the packaging is different, the shape of the packaging is new, then it can be a design. But otherwise, if it's the artistic work, the color scheme, the imagery that comes on the product packaging that needs to be protected, then it is trademark. A simple example is the product packaging of, let's say, a KitKat chocolate. The wrapper, the product packaging of, the Pepsi bottle, the blue and red color combination that you see, all those are eligible for trademark. So product packaging, if it relates to the artistic images or the logos or the artistic content that you see there, they can be registered as trademarks. But if there's something in the packaging that has uniqueness in the shape of the packaging, then that can be registered as a design, provided it is not disclosed to the public. Yeah, I think that's all from my side. I hope you got a clear idea of, at least I know from the answers that many of you, understood at least the difference between the different kinds of IP and will be in a position to, kind of understand or at least distinguish what each kind of intellectual property is. Any other questions, anyone?
Hi, ma'am. Hello.
Yeah, go ahead, sir.
Ma'am, actually, I'm a faculty from the with a background. So I have a doubt.
Department of, sir, either department,
Department Artificial Intelligence, computer science
okay,
background.
okay, sir.
Okay.
Okay, sir.
Ma'am, actually, a doubt. Normally, we write some algorithms in during our PhD work, right? Upon nammal each in PhD work, algorithms could be is it നമുക്ക് അതിനകത്തൊരു കോപ്പിറൈറ്റ് ഇൻഷുറൻസ് കണ്ടിട്ടുണ്ട്. IPR എന്നൊക്കെ പറഞ്ഞിട്ട് ചിലർ ഫയൽ ചെയ്യുന്ന കണ്ടിട്ടുണ്ട്. അപ്പൊ അത് നമുക്ക് അങ്ങനെ ചെയ്യാൻ എന്തൊക്കെയാ സ്റ്റെപ്സ്? അതോ നമ്മളൊരു പേപ്പറിൽ പബ്ലിഷ് ചെയ്ത് കഴിഞ്ഞാൽ അങ്ങനെ നമുക്ക് പ്രൊസീഡ് ചെയ്യാൻ പറ്റത്തില്ല? എന്താണ് അതിന്റെ ഒരു
കോപ്പിറൈറ്റ് ഫയൽ ചെയ്യാനായിട്ട് ഈ പബ്ലിക്കേഷനുമായിട്ട് ഒരു ബന്ധമില്ല. ബിക്കോസ് നിങ്ങൾ പബ്ലിഷ് ചെയ്ത ആൽഗോരിതം ആണെങ്കിലും യു കെൻ അപ്ലൈ ഫോർ എ കോപ്പിറൈറ്റ് രജിസ്ട്രേഷൻ ഫോർ എൻ ആൽഗോരിതം. ആൽഗോരിതം മാത്രമാണെങ്കിൽ അതിനൊരു പേറ്റന്റ് എലിജിബിലിറ്റി ഇല്ല. പേറ്റന്റിൽ മാത്രമേ നമ്മൾ പബ്ലിഷ് ചെയ്യാൻ പാടില്ല എന്നൊരു റിക്വയർമെന്റ് ഉള്ളൂ. കോപ്പിറൈറ്റ് ഫയൽ ചെയ്യാനായിട്ട് നമ്മൾ പബ്ലിഷ് ചെയ്തതാണെങ്കിലും നമുക്ക് കോപ്പിറൈറ്റ് ആപ്ലിക്കേഷൻ ഫയൽ ചെയ്യാം. പക്ഷെ നമ്മളൊരു ആൽഗോരിതം പബ്ലിഷ് ചെയ്യുമ്പോൾ തന്നെ നമുക്ക് ഓട്ടോമാറ്റിക്കലി കോപ്പിറൈറ്റ് ആയി. അപ്പൊ അതുകൊണ്ട് കോപ്പിറൈറ്റ് രജിസ്ട്രേഷൻ ഇസ് നോട്ട് മാൻഡേറ്ററി.
ഓക്കെ. അപ്പൊ നമ്മൾ കോപ്പിറൈറ്റിന്റെ ആ ഒരു സ്റ്റേജസിലേക്ക് പോവുകയാണെങ്കിൽ നോർമലി അപ്പൊ നമ്മൾ അവരെന്താ ഇൻഷുർ ചെയ്യുന്നത്? അതിനകത്തൊരു അപ്പൊ അവരെങ്ങനെ ക്രോസ് ചെക്ക് ചെയ്യും? നോവൽറ്റി ആണോ നോക്കുന്നത്? അതോ
വെരി ഡിഫിക്കൽട്ട്. ഇപ്പൊ ആൽഗോരിതംസ്, കമ്പ്യൂട്ടർ സോഫ്റ്റ്വെയർ ഒന്നും അവർക്ക് ഒരു രീതിയിലും ചെക്ക് ചെയ്യാൻ പറ്റത്തില്ല. അതിനുള്ള ഒരു സിസ്റ്റം ഒന്നും നമ്മുടെ കോപ്പിറൈറ്റ് ഓഫീസിലൊന്നും ഇല്ല. ബട്ട് നമ്മളത് പല കമ്പനീസും ഫയൽ ചെയ്യാറുണ്ട്. കമ്പ്യൂട്ടർ സോഫ്റ്റ്വെയറിന് പലരും ഫയൽ ചെയ്യാറില്ല. അതിന്റെ ഒരു റീസൺ എന്താന്ന് വെച്ചാൽ, ഇപ്പൊ ഫോർ എക്സാമ്പിൾ സോഫ്റ്റ്വെയറിലാണെങ്കിൽ നമ്മൾ ഇന്ത്യയിൽ കോപ്പിറൈറ്റ് ആപ്ലിക്കേഷൻ ഫയൽ ചെയ്യണമെങ്കിൽ സോഴ്സ് കോഡ് കൊടുക്കണം, ഒബ്ജക്ട് കോഡ് കൊടുക്കണം. സോഴ്സ് കോഡ് പലരും ഡിസ്ക്ലോസ് ചെയ്യാൻ തയ്യാറാവില്ല. അതുകൊണ്ട് തന്നെ നമ്മൾ കമ്പ്യൂട്ടർ സോഫ്റ്റ്വെയറിന് കോപ്പിറൈറ്റ് ആപ്ലിക്കേഷൻ ഫയൽ ചെയ്യുന്നത് വെരി റെയർലി ആണ്. പിന്നെ ഇത്
അൽഗോരിതംസിൽ നമ്മളിത് റൺ ചെയ്ത് റണ്ണബിൾ കോഡൊക്കെ നമ്മൾ അന്നേരം കൊടുക്കേണ്ടി വരും. അതിന്റെ അതിന്റെ ഔട്ട്പുട്ട് എല്ലാം നമ്മൾ കാണിക്കേണ്ടി വരും അല്ലേ?
കാണിക്കേണ്ടി വരും. നമുക്ക് എന്താണോ പ്രൊട്ടക്ട്, ബിക്കോസ് നമ്മുടെ എക്സ്പ്രഷൻ ഓഫ് ദാറ്റ് ഐഡിയ ആണ് പ്രൊട്ടക്ട് ചെയ്തിരിക്കുക. അപ്പൊ നിങ്ങൾ എന്ത് ഡിസ്ക്ലോസ് ചെയ്യുന്നു അതിനാണ് നിങ്ങൾക്ക് പ്രൊട്ടക്ഷൻ.
ഓക്കെ ഓക്കെ. അത് ഈ നമ്മൾ നോർമലി പേറ്റന്റിനൊക്കെ അപ്ലൈ ചെയ്യുന്ന പോലെ ഒരു ടൈം പീരീഡ് ആണോ ഇതിനുള്ളത്? നോർമലി മറ്റേതൊക്കെ 1 year എടുക്കാറില്ല. അത്രയും ഒരു ടൈം പീരീഡ് ഇതിനൊക്കെ ഉണ്ടാവാറുണ്ട്.
രജിസ്ട്രേഷൻ കിട്ടാനോ? കോപ്പിറൈറ്റ് രജിസ്ട്രേഷൻ നോർമൽ കേസിൽ ഒബ്ജക്ഷൻ ഒന്നും ഇല്ലെങ്കിൽ 6 to 8 months കിട്ടാറുണ്ട്.
ഓക്കെ ഓക്കെ മാം, ക്ലിയർ ആണ്. താങ്ക് യു.
താങ്ക് യു സർ.
ഓക്കെ.
വേറെ ക്വസ്റ്റ്യൻസ് എന്തെങ്കിലും ഉണ്ടോ?
Any other queries?
ചാറ്റിൽ ക്വസ്റ്റ്യൻസ് ആരെങ്കിലും ഇട്ടിട്ടുണ്ടോ?
ഒരു ക്വസ്റ്റ്യൻ ചാറ്റിൽ വന്നിട്ടുണ്ട്.
NFTസിന്റെ പ്രൊട്ടക്ഷൻ എന്ന് പറയുന്നത് ഇപ്പോഴും ഇന്ത്യയിൽ ഒരു ഗ്രേ ഏരിയ ആണ് കേട്ടോ. NFTസിന് ഇപ്പം NFT ആസ് ലോങ് ആസ് ഇറ്റ് ഇസ് ഒരു സോഫ്റ്റ്വെയർ ബേസ് ഉള്ളതാണെങ്കിൽ അതിനൊക്കെ കോപ്പിറൈറ്റ് പ്രൊട്ടക്ഷൻ മാത്രമേ ഉള്ളൂ. NFT ബേസ്ഡ് ആയിട്ടുള്ള പ്രോഡക്ട്സിന് വേണമെങ്കിൽ എന്തെങ്കിലും, പക്ഷെ ആർട്ടൊക്കെ ആണെങ്കിൽ ഓൺലി കോപ്പിറൈറ്റ് പ്രൊട്ടക്ഷൻ ഇസ് എലിജിബിൾ. പക്ഷെ ഇന്ത്യയിലൊക്കെ ഇപ്പോഴും ഈ പറയുന്ന കൂട്ട് ബിക്കോസ് ഓഫ് ഓൾ ദീസ് ഇഷ്യൂസ് എന്താ പറയുക, പ്രൊട്ടക്ഷൻ എന്താണെന്നുള്ളത് ഒരു ഗ്രേ ഏരിയ തന്നെയാണ്.